Back on the record, the time is 3:37.
Dr. EGILMAN, how many football-related cases have you testified in?
I think this is the second.
The first one was the Sheely case.
Yes?
So the two football-related cases you've testified in have been against the NCAA?
Yes? Well, no.
Well, I'll follow up on that. The NCAA was a defendant in both this case and the Sheely case, correct?
Yes?
In the Sheely case, also the university was a defendant, correct? The school?
I don't think so, no. I think you can't sue the school in Maryland. I think,
Okay.
as I recall.
Were the individual coaches defendants?
I think so, yes?
Was there a trainer that was a defendant?
I think so, yes?
And the NCAA?
And the helmet manufacturer.
And the helmet manufacturer, all in the Sheely case.
Right.
And in the Sheely case,
And I think the distributor of the helmet. Maybe the distributor, not this. I can't remember exactly. Is either the distributor of the helmets or the helmet manufacturer or both. I think the helmet manufacturer had gone bankrupt.
okay.
Okay, so I think it was the distributor of the helmet.
And in the Sheely case, did you have an opinion that the individual coaches had a duty or obligation to keep Mr. Sheely safe?
I can't recall my opinions in that case.
Did you have opinion? You don't recall any opinion you had in the Sheely case at all?
I don't recall the questions and answers or the exact opinions I gave in that case, no. I haven't reviewed that testimony. Was that 4 years ago?
The Sheely depositions were part of your reliance materials in this case.
Yeah, I understand that, but I gave them to you because they're relevant. But they're not. Doesn't mean I read them again. I read them a long time ago.
Do coaches have an obligation to protect athletes from harm?
Yes.
Do athletic trainers have a duty to protect athletes from harm?
Yes.
Do team physicians have an obligation to protect athletes from harm?
Yes.
Do universities themselves have an obligation to protect athletes from harm?
Yes.
The obligation of, and I can break them up individually if you want, but I'm going to try to do them as a group. The obligation of the university and the coaches and the trainers and the team physicians, their obligation to keep athletes from harm is independent of whatever the NCAA tells them to do, correct?
Object to the forms mischaracterizes the evidence and the testimony of your own people who said the NCAA's members are the NCAA. You're misrepresenting the law and the facts.
I'm just asking them a question.
And I'm pointing out you're answering asking a
Well,
misleading question.
We can keep it to objection form.
We could, but I'm not going to let you mislead them.
I'm not misleading them.
Yes, you are.
I'm asking them a
Why
question.
don't you read what your own witnesses said? They said that the schools aren't different than the NCAA, and you're implying they are.
Let me ask you this. So,
Wait a minute. You don't want me to answer the previous question? You would. I didn't answer. You want me to answer?
yeah, answer it.
No.
So, the obligation of a coach to keep a student athlete safe is limited to whatever the NCAA tells that coach to do?
No.
So, the coach's obligation to keep a student athlete safe is not necessarily dependent on what the NCAA instructs that coach to do, correct?
Object to the form.
Not necessarily. That's not necessarily correct. No.
You've reviewed the rules of football for 1965, 1967, correct?
Yes.
Do you recall any rule stating that there has to be water on the sidelines during games?
No.
Are you aware that generally there's water on the sidelines during games?
I'm not aware that there's water.
Gatorade, liquid, something to quench the thirst of an athlete?
Yes.
Okay. So how is it, if there's no rule requiring that there's water on the sidelines during games, how does that water end up there?
Well, you know, I don't know how that water ends up there. I'm not, that's part of this I haven't studied on. Okay, but I'll see if I didn't see it in any of the documents. I didn't see it in any of the documents in the Shealy case, which involved the colleges and the coaches. I just don't know how the water ends up there, or the Gatorade, or whatever they pick. Oh, I know some. Oh, you know what? Some of that ends up because those companies pay the NCAA. I think so. Like Gatorade pays the NCAA to be the official drink of something or other. Okay, and so some of that water's there because the NCAA gets money from it. Okay.
Do you know that to be the case in college football?
Hold on. Were you done with your answer, Doctor?
I don't know for sure, but that's what I think.
Okay.
I think I've seen something like that. I haven't seen those contracts either, but since you asked, that's my general recollection, is that if you want to get your logo, and when your logo's on those bottles, okay, into an NCAA venue, I think you got to pay them.
I'm not talking about logos. I'm talking about some form of liquid to quench the thirst of an athlete on the sideline. Okay, whether it's water or Gatorade or anything else. I'm not talking about logos on a container. But
Your question, sir, just to be clear, I don't know what you're talking about. You're asking questions. Your question was, do you know how whatever gets there gets there? And my answer was, I know part of that answer, I think. I'm not 100% sure, but I think part of the way that stuff gets there is those folks give a check to the NCAA or the college or both, and that's how that beverage gets there.
would you agree that it's a good idea for a coach to make sure that there's a beverage on the sideline to make sure that their athletes can get proper hydration?
Check to the form.
Depends on the beverage.
Water, Gatorade, Powerade.
For those beverages, yes. For most of the players. If you're Jay Cutler, the Gatorade Powerade wouldn't be a good idea.
Objection non-responsive. I don't know why Jay Cutler can't have that.
Because he's diabetic.
Okay. Has any court excluded part or all of your testimony?
Yes.
And how many times has a court excluded part or all of your testimony?
Once.
And that was pursuant to the Daubert standard?
Correct.
What case was that?
I can't recall. It was a diacetyl case.
You've often testified regarding product warnings, correct?
Yes.
Have you ever drafted a warning for a product that was actually used on the product as sold in the marketplace?
I think so.
You've actually drafted a warning that ended up on the product in the marketplace?
Well, I consulted with Federal Mogul and gave them recommendations about what their warnings should be on some of their products. And I think some of the advice I gave them ended up on their warnings in the market.
Just part of the advice, or did they adopt the warning that you provided?
I don't know.
And you don't know for sure if part of your warning made it on the label, or you think it might have? You just don't know?
I'm pretty sure it did.
Have you ever drafted a warning that was actually given to people signing up to participate in an organized sport?
No.
Have you ever designed a study to test the effectiveness of a warranty? I'm sorry. Let me start over. Have you ever designed a study to test the effectiveness of a warning?
Yes.
How many times?
Once.
When was that study?
Late 80s, early 90s, I think.
Did that relate to paint cans?
Yes.
Were the results of that study published?
I think I issued a report to the EPA.
Were they published in a journal?
No.
Were they peer reviewed in any way?
I don't know what the EPA did with it.
In the study that you designed, was it by questionnaires that you asked people about the warnings? I'll ask you this way.
Not,
How did you test the effectiveness of the warnings in that study?
I designed a questionnaire to ask them about what they thought the risks were from exposures and what they understood the terminology to be on the label. In particular, we focused on the language adequate ventilation, in quotes.
Have you authored any articles on the issue of anti-warranties?
No?
Object to the form.
Did you ever play football?
Yes?
At what level?
8th and 9th grade. Maybe just the 9th grade. Maybe just the 8th grade. One of them grades. 1 or 2 years.
Around what year would that have been? You don't have to do the exact math. If you can give me mid whatever.
Well, I don't know, mid-60s probably. So I was born in 52, so I would have been like 14 or 15. So that would have been 66 or 67.
Did you receive any warnings about the long-term effects of playing football when you participated?
Kind of, sort of.
About the long-term effects of playing football?
Well, it wasn't really specified.
What was the warning that you're referring to?
The insurance policy for high school said it didn't protect you if you were, didn't cover you if you were a football player. That warning was sufficient to get me to not play high school football. I figured if the insurance companies knew they shouldn't insure me, it probably wasn't smart for me to do the sport.
And you found that out on your own?
Yeah, I read the health insurance thing, and that's what it said. It said exclusions for football. So I figured it out that if the insurance company was excluding football, it might not be something I want to do, since I knew then insurance companies were really smart in terms of making money. If they thought they were going to lose money insuring people covering football when they could increase the premium, etc., I figured that out.
Objection non-responsive. Did you read the that insurance policy as a way to protect yourself, your duty to yourself to investigate what you're getting yourself into?
Object to the form.
I do not understand that question.
Well, you said you found out about the insurance policy, right?
Yes.
And that was as a result of they showed you some form that you had to fill out, and there was a statement on there about what the insurance was and was not going to cover?
Apparently. I don't remember all the details, but apparently something like that.
And you paid attention to that form because you wanted to know what you were getting yourself into when you signed up, right?
No.
Object to the form.
Not at all. I wasn't motivated at all. I just read it as part of standard. You read things before you. I used to read things before I signed them. For some, not everybody does that, but I used to do that. I guess, I did that, and that's why. And I mean, I wasn't looking for anything. The information was available.
Do you have any children?
Yes.
Any of them play football?
Yes.
Was it organized football?
Well, I think
Well,
it was
as a-
technically organized, but I mean, I went to the games. It looked that organized to me.
As
But but I mean, they had uniforms and they had a coach and it was a league, but it wasn't that organized.
I'm just drawing a distinction between backyard sandlot football and maybe at a middle school or a high school. Middle school or high school being organized, sandlot football being just kids playing in the dirt.
Yeah. Okay. So you defined it. Now you want me to answer? You got a question?
Yeah. Did your son play organized football?
By that definition, yes.
Okay. What level did he play?
Junior high school.
What year would that have been? Roundabout.
Let's see. He's 25. So he played the same time I did. So minus 12. So it would have been 12 years ago, maybe?
That's 2006.
That would be 12 years ago.
What
I could
position?
be off by a year or two.
What position did he play?
He played running back and linebacker.
When he signed up to play football, did you provide him any warnings about the long-term effects of playing football?
Nope.
Did you do any research yourself about the risks of letting your son play football?
No. Other than what you would know watching games.
Do you consider yourself to be primarily a scientist or an advocate?
Check to the form.
The question makes no sense. It's not an and or. There is a science of public health which advocates for public health. It's the same thing. Public health is advocating for people to be healthy. Practicing medicine is advocating for people to be healthy. You use science as a tool, in part, to advocate for health.
Medical and scientific knowledge has changed over time, correct?
Some has,
Some has.
not all. For example, CTE was known in 1000 and it's known now.
And the cause of CTE was known in 1000?
It was associated with trauma, I think, according to Rhazes. R-H-A-Z-E-S.
Would you agree that doctors and scientists can have a good faith disagreement over the interpretation of articles and the conduct of studies?
Check to the form.
Yes, that's possible.
And doctors and scientists can look at and interpret some of the very same things that you look at and interpret them completely different, correct?
Check to the form.
Yes, that's possible.
So you can look at something, somebody else can look at the same thing and come to different conclusions.
Yes, that's possible under some circumstances.
And that would be true for example, if you were both looking at medical textbooks, correct?
Check to the form.
I don't understand that
Okay.
that add-on to that question.
For example,
Try a complete question.
Okay.
It'll help us.
For example, you can look at an article and another doctor or scientist can look at the same article and have a different interpretation than the one you arrive at, correct?
That is possible.
And you can look at a medical textbook and another doctor or scientist can look at the same medical textbook and have a different interpretation than you arrive at, correct?
That's definitely possible. We could be reading different chapters.
You can read the same chapter and come to a different interpretation, correct?
That's possible.
And you can look at a trade journal and another doctor or scientist can look at the same portion of the trade journal and have a different interpretation than you arrive at, correct?
That's possible.
The same would be true for information conveyed in corporate documents, right?
Depends on the information, but it's possible.
People can disagree and still be reasonable in their interpretations, correct?
That's possible.
How many medical articles were there on the long-term risks of playing football as of 1972?
I don't know the exact number, but actually, I have we have a graphic here on the numbers by decade, I think. So I have that number, but I don't have it memorized. But we have a graphic, by decade of how many articles were published.
Okay.
I'll see if I can find that in the next break.
Uh,
Okay.
Do you
But
know-
It's not going to be I don't know if you can get an exact number because we're just going English speaking here. Okay, we're not. I mean, I didn't look at, Russian, Chinese, French
understand.
literature, German literature. So this we're talking about, for the most part, English language literature. A lot of the PubMed stuff I would look at would not at that before 72 wouldn't have other languages. Now it has more other language stuff. Like Polish stuff doesn't get in there very much.
Okay.
I'm Polish.
Do you know how many medical articles were written on football and CTE as of 1972?
Per se, no.
Do you know how many medical articles were written on football and punch drunk as of 1972?
No.
Do you know how many medical articles were written on dementia pugilistica and football as of 1972?
No.
Do you know how many medical articles there were on the long-term risks of concussions and CTE as of 1972?
No.
Do you know how many medical articles there were on long-term risks of repetitive head injuries and CTE as of 1972? Do
No.
you know how many medical articles there were on the long-term risks of mild traumatic brain injury and CTE as of 1972?
No.
Are you familiar with the summary and agreement statement of the First International Conference on Concussion in Sport, Vienna 2001?
I've read it.
So you're familiar with it?
Well, I haven't memorized it. I haven't read it for a couple of years.
I believe we're on Exhibit 4. I'm going to hand you what's marked as Exhibit 4. Is Exhibit 4 the summary and agreement statement of the First International Conference on Concussion in Sport, Vienna 2001?
Yes?
If you look in the middle of the page where it says a revised definition of concussion,
Yes?
about 1, 2, 3, 4, 5, 6, 7, 8 lines down, there's a sentence that starts with, this definition was,
Yes?
you with me?
I know where you are in the paper, yes?
Okay. It states, this definition was recognized as having a number of limitations. Oh, hang on. Let me start at the top of that paragraph. Right under a revised definition of concussion. It says, over 35 years ago, the Committee on Head Injury Nomenclature of the Congress of Neurological Surgeons proposed a consensus definition of concussion. Did I read that correctly?
Consensus is in quotes. Other than that, yes.
And then below that, there's the sentence that starts with this definition. You with me?
No.
Well, 1, 2, 3, 4 lines below that, there's a sentence that starts with this definition.
Yes.
And it states, this definition was recognized as having a number of limitations in accounting for the common symptoms of concussion. Did I read that correctly?
Yes.
In addition, there was an inability to include relatively minor impact injuries that result in persistent physical and or cognitive symptoms. Did I read that correctly?
Yes.
Seeking to transcend these limitations, the CISG has developed the following definition of concussion. Did I read that correctly?
Yes.
And CISG is the Concussion in Sport Group. You agree with that?
Yes.
Okay. So you agree that the previous definition, do you agree with the statement in this exhibit that the previous definition had a number of limitations?
Check to the form.
I don't recall.
You don't recall if you agree with this statement?
Correct. You'd have to show me the previous definition, and then I can see if I recollect having thought that there were limitations.
Well, then the second paragraph where it starts concussion is defined. Are you with me?
Yeah, it's in quotes again. It starts with quotes.
Quote, concussion is defined as a complex pathophysiological process affecting the brain induced by traumatic biochemical forces. Did I read that correctly?
No.
Try it again. Concussion is defined as a complex pathophysiological process affecting the brain induced by traumatic biomechanical forces. Did I read that correctly?
Yes.
And that's a new definition of concussion being proposed in 2001.
No.
Well, it goes on, this summary and agreement statement goes on to say several common features. I'm not trying to read all the rest of it, but you would agree that this summary statement is providing a new definition of concussion.
Object to the form.
What are you talking about here? I don't understand what you mean when you say this summary statement. You read one sentence of 7 paragraphs, and not all of the 7 paragraphs are new.
So in the beginning of the paragraph, it talked about over 35 years ago, a consensus definition of concussion was provided. And then this summary and agreement statement is attempting to provide a new definition of concussion. Do you agree with that?
No, not exactly.
They're proposing a new definition? Do you agree with that?
No, not exactly.
What's incorrect about my statement?
Well, first, they developed one. Secondly, my recollection is, but I need to check, that there's 6 paragraphs here, 5 paragraphs of definition, and I believe there's overlap from these items to the previous definition. So it's not, some of it is, there's some differences, but most of it's the same or identical to the previous definition.
But there are changes being made, at least in some respects, to the definition of concussion under Exhibit 4.
Well, I don't know about change as. They refer specifically to the previous lack of inclusivity of relatively minor impact injuries that result in physical or cognitive symptoms. So that's the one thing that appears to have been added to the previous definition. So you said things, that's one thing. I don't know about the other things. I'd need to compare them to answer the question.
Okay. I'm going to hand you what's being marked as Exhibit 5. Do you recognize Exhibit 5 as the consensus statement on concussion in sport, the 5th International Conference on Concussion in Sport held in Berlin, October 2016?
My
Yes.
apologies, Doctor. Can you give me exhibit number 4 so I can keep them straightened out?
You want a
Please.
copy? You want your own copy of these?
No, I have one. I'm just trying to keep the court reporters in.
Okay.
in
You
place
got a
right
copy of 4 and 5?
I do. I have 4. I don't have 5 yet. Unless that's what that's. I don't know. Is that what that is?
This is Exhibit 5.
I have 5.
Do you recognize Exhibit 5 as the consensus statement on concussion in sport, the 5th International Conference on Concussion in Sport held in Berlin, October 2016?
Yes.
And there's a number of authors to this article. Do you recognize Robert C. Cantu?
Yes.
He is an expert for plaintiffs in this case, correct?
He's consulting at the request of plaintiffs in this case, correct?
And you see the statement where it says preamble, and then the paragraph right below that.
Yes?
The last sentence of that paragraph, it says, while agreement exists. Are you with me?
Yes.
It states, while agreement exists on the principal messages conveyed by this document, the authors acknowledge that the science of SRC is evolving and therefore individual management and return to play decisions remain in the realm of clinical judgment. Did I read that correctly?
Yes.
Do you agree that the science of SRC is evolving and therefore individual management and return to play decisions remain in the realm of clinical judgment?
Object to the form.
I don't know what that means. And the answer is no.
Is
Because by this time, there are institutions that are making requirements based on a variety of issues about return to play.
Let me back up for a second. Exhibit 4, we looked at a second ago.
Yes?
Do you believe Exhibit 4 is a reliable authority on concussion in sport?
Object to the form.
I don't know what you mean by that.
Have you ever relied on that article in the past?
I don't recall.
Have you ever cited to it in an article or in an expert report?
Probably. Oh, yeah, I've cited this.
And you've cited it as authority for a proposition related to concussion in sport?
I, I don't recall what I cited it for. I may have just cited it as it existed. Okay, I don't know if I quoted from it or cited it for a specific item, but if I did, that wouldn't mean I thought it. I don't know what. There's no medicine is not the law. In law, you have authoritative cases, etc. That is not how medicine works. Medical literature is not authoritative in that it can be cited and followed as you might follow a case, an authoritative case. That's the law. Medicine doesn't work that way.
Do you believe that Exhibit 4 is a reliable source of information related to concussions in sport?
Object to the form. Asked and answered.
Too broad a question. I need to go through each sentence here and tell you whether I think that's reliable or not, whether it's based on reliable information. I'll be glad to do that if you want.
No, thank you. Turning back to Exhibit 5.
Bless you.
Do you believe that Exhibit 5 is a reliable source of information related to concussions in sport?
Object to the form.
It's the same answer I just gave you. I don't do things. First, I haven't read it in a while. I need to reread it. Secondly, that's not how medicine does things.
Okay.
It's not a case that you can cite for a proposition or authority on how another case should be done. It's a paper that discusses things. This in particular is a review paper that discusses things. And it may be reliable on some things, it may not be reliable on some things.
You see,
At the same time.
you see under preamble the second paragraph. It starts with this consensus document.
Yes?
When's the last time you read this document?
I don't recall.
Okay.
But it's been, it came out came out in 18? I don't recall.
The second paragraph here says this consensus document reflects the current state of knowledge and will need to be modified as new knowledge develops. Did I read that correctly?
You did.
Do you agree that the consensus document reflects the current state of knowledge related to concussion in sport
Object to the form.
Current being when?
as of October 2016?
Object to the form.
I don't know. I need to read it.
When you read it the last time, do you recall if you thought that the consensus document reflected the current state of knowledge
I knew it didn't.
at the time you read it last?
Right. I knew it didn't. It couldn't. Because the current state of knowledge has been kept confidential by the NCAA. Current state of knowledge will only become currently available after this deposition ends. So everything I've talked about that related to what the NCAA knew and hid could not be incorporated into the current public knowledge base because no one knew about it except the people at the NCAA.
Objection non-responsive. Have you seen the protective order in this case?
I have.
Do you understand that the protective order states that this deposition remains confidential for at least 7 days after this deposition concludes?
That I understand.
And it can be marked confidential up until that time?
That I
Well,
understand.
first of all, no, you can't just say the whole deposition's confidential. You have to mark particular parts. Two, we haven't talked about anything that meets confidentiality under the protective order in this case.
We'll go through that process. I'm just saying that it is not a foregone conclusion is my only point.
Oh, it's a foregone conclusion.
I understand. That's
I
your
mean,
position.
No, it's not. It's a fact.
Where it says
Let me
medical,
ju-
I
where,
understand that you all will want to hide it and come up with a bogus designation.
I'm gonna move forward with my questions. Do you,
Well,
do you
no,
see on
you're
the
not
do
going
you
to
see
make
on
a
the first
speech
page?
and then tell me I don't get to respond.
I'm just asking the.
You made a comment.
Okay. Do you see on?
You intend to designate
do you
this
see on-
deposition confidential?
Dr. Eagleman?
No, you're going to respond to my question because you made a comment.
There may be portions of this deposition that
What
we
do
will
you
designate.
believe that's happened so
we
far
will,
as confidential?
we will cross that bridge
You haven't
after I get the
designated
transcript.
a single deposition confidential in this
The
case.
the medical.
And I promise you, I
Do
will ask
you-
for sanctions if you
do-
intend to fraudulently say
Dr.
that something
Eagleman.
in this is confidential.
Dr. Eagleman.
Raising your voice doesn't change the fact I get
Do
to
you see where it says
respond.
medical legal consideration?
Excuse me. Do not talk over me.
I'm
You made
asking
a comment
question.
on the record, which I'm responding to.
That's fine.
Then
It's
stop
done.
talking over me.
I'm moving forward with my
When I'm
question.
finished, you can.
No,
yeah.
I am asking my
Okay,
question.
you want to go off the record and take a break then? Because you are not finishing.
No, I do not want to go off
You
the
are not
record.
asking him another question until I'm finished. Period.
We can go off the record, and then you can tell me whatever you
No,
want.
you
but
shouldn't have made
You're
your,
not doing this on
you
my
shouldn't have
time.
made your extraneous comment on your time.
Dr. Eagleman,
Excuse me, I'm not finished. You're refusing to tell me right now if you think something in here is confidential.
I'm not obligated to tell you right now.
That's
whether
not what I
something's
asked you.
I'm not obligated to right now, so I'm not
Right.
going to.
That tells us all we need to know, doesn't it? Just like you eating candy and texting while he testified for 3 hours
You have
to
no-
answer all these questions.
You have no idea what I was doing on my phone.
I saw you.
Do you see
You were
on the
asking
first
people
page?
what to do.
Oh, so let me get this straight. You were reading my notes and communications?
No, I have common sense. I know what you were doing.
You were either reading my privileged communications,
From
or you're
across
or
the
you're
table?
or you're completely guessing.
No, I'm not.
So which
guessing.
one is it? You're either making it up or you were doing
I'm
it.
definitely not guessing because I
Okay.
know exactly what you did. Somebody said, "Why don't you ask if he'll do it
Dr.
direct?
Eagleman.
Why don't you ask to call the judge?"
Dr.
It's not
Eagleman.
rocket science.
Dr. Eagleman.
What, you want to comment and then you don't want to continue?
Do you see on the first page where it says medical legal considerations?
That's what I thought.
Can we just, 1 second, I need to correct my previous answer.
Okay.
The deposition, sections of the deposition, you can, in 7 days, mark confidential.
Okay.
However, all these exhibits that I brought with me, there's been no 76A hearing in Texas. None of these documents can be sealed pursuant to a 76A hearing that hasn't occurred. So it's my understanding that you couldn't make any document at this deposition confidential because there haven't been a 76A hearing to allow you to do so, to seal anything at this deposition. And it's the documents that will come out at the end of this deposition because there's no 76A hearing, there's no basis to seal anything here.
Do you intend to
And none of these Blitz documents have been designated confidential anyway.
release publicly release documents at the conclusion of this deposition?
Anything I can release that I think is legal to release, I'm releasing
Immediately after this deposition?
as soon as I can,
Do you see on the first page of
which
Exhibit
could be
5?
immediately after this deposition.
Do you see on the first page
Could
of
be
Exhibit
during this deposition.
Do you
Go
see
ahead.
on Do you see on the first page of Exhibit 5 where it says medical legal considerations?
Where you look? Oh, yeah. Mhm.
And 1, 2, 3 lines down it says this document is.
Correct.
It says this document is only a guide and is of a general nature consistent with the reasonable practice of a healthcare professional. Did I read that correctly?
You read that sentence correctly. Out of context.
Do you agree that this document is consistent with the reasonable practice of a healthcare professional as of October 2016?
Object to the form.
I don't know, we'd have to go through it section by section.
You see on the second page?
Yep,
Where it says, recognize what is the definition of SRC?
yes,
You understand SRC is sports-related concussion?
yes,
On the second paragraph, under what is the definition of SRC, 1, 2, 3, 4 lines down, there's a sentence that starts with the term.
right,
It states the term concussion, while useful, is imprecise, and because disparate author groups define the term differently, comparison between studies is problematic. Did I read that correctly?
yes.
Do you agree with that statement?
May or may not be true.
You don't know one way or the other?
You can't make a broad statement like that about every study that's ever been done and be true all the time unless you've checked every paper and compared it to every other paper, which is what that statement attempts to do. So it's an overly strong statement unless they do some kind of an analysis comparing the criteria used in different studies to see if they're different, if it would make a substantial difference in the conclusions found in that paper compared to the other paper.
You turn to page 844. It's on the bottom left-hand corner, the page numbers. Or at least 844 is.
This just came out, this paper.
What?
This paper, as I recall, is relatively recent.
It's got a 2018 date on it on the bottom of the page.
Right, that's what I said. It's recent.
Oh, you're on page 844?
I am.
You see residual effects in sequela? Am I pronouncing that word correctly?
Yes,
The second paragraph, it's in italics.
yes,
The first sentence says, the literature on neurobehavioral sequela and long-term consequences of exposure to recurrent head trauma is inconsistent. Do you agree with that statement?
Object to
Let me read the
form.
context.
Let me go off the record while he's reviewing it.
No.
I gotta use the restroom. Let's go off the record while I use the restroom.
Going off the record, time is 4:20.